guest speaker for this August event. Our speaker for today, Professor Konyinsola Ajayi, SAN, attended the Gobi College between 1971 and 1975, and he also attended the University of Ife, now called Obafemi University. Not only did he obtain several distinctions in his studies in this university, but was also named a federal scholar for the entire period of the program. He was called to the Nigerian bar in 1980, and he went on to obtain an LLM from Harvard University in 1982 and a PhD in international markets from Cambridge University in 1991. Our speaker for today has authored and co-authored over 130 legal writings under the heads of energy and natural resources law, banking law, corporate and commercial law, project finance, and international capital markets. He is also a professor of law at the Babcock University, Ileshan Remo in Ogun State. Our speaker for today has been described by Chambers Global as, I quote, a legend in the industry, end of quote. He is recognized as one of the leading banking and finance, corporate and commercial law, commercial litigation, project finance, and capital market lawyer, as well as energy and natural resources in the world by Chambers and Partners, Who is Who Legal and International Finance Law Review, respectively. He has been described by Chambers and Partners as, in quote, unarguably one of the best in Nigeria. Ladies and gentlemen, our dear speaker is unable to join us at this event. However, he has nominated a Pegasus Scholar of the Inner Temple, Inns of Court, England, a man with first-class honors from Nigeria Law School, and a man who won a lot of prizes and was the best overall candidate out of over 5,000 candidates at the 2005 bar examinations. His nominee subsequently obtained an LLM in commercial law from St. Edmund's College, University of Cambridge, and recently had a stint as a visiting senior associate at Allen and Overy LLP, a global law firm where he worked with the projects and banking and finance group. Ladies and gentlemen, it's my pleasure to introduce to you the representative of Professor Konyinsola Ajayi, SAN, and the person of Mr. Jonathan Aluju, a partner in the law firm of Olaniwun Ajayi LP. Ladies and gentlemen, please welcome Mr. Jonathan Aluju as he makes his presentation on the theme of this roundtable, ethical governance in the boardroom, implications for stakeholders. Mr. Aluju, sir, you have the floor.
Good morning, everyone. First of all, my greetings to His Royal Highness. It's a pleasure to have you here with us, and all other protocols duly observed. First of all, I would like to convey the apologies of Professor Konyinsola Ajayi, who is not able to join us, is out of the country, and then something came up such that he couldn't handle this session. But definitely holds this association in very high esteem, and he sends his kind regards. So that said, it's quite a daunting task, I would say, to be stepping into the very big shoes of Professor Konyinsola Ajayi. But I want to believe, having been under his tutelage for over a decade, that I would at least try to or pretend to show a part of him, right? I believe the audience here would have really loved to see him speak. But as I say, things happen. But I'm here to do the best I can. I'm standing in for him. So it's a pleasure to have, to be here to make this keynote address. And I want to say thank you to the ICSAN for this privilege of taking this presentation, which focuses on ethics in the boardroom. Very key, topic or area of discourse if there's to be sustainability in the market and in the management and operations of our companies. Now, to start with, profit maximization is the key consideration in setting up most business concerns, particularly limited liability companies that are limited by shares, right? That is the driving force. So if you're not setting up a company, an NGO purpose or a limited by guarantee company, definitely the grand objective is to make profit. Now, with that objective comes the temptation of sometimes overly focusing only on activities aimed at generating revenue, ensuring maximum returns on investment for the shareholders who have invested their funds in the company, and of course, catering for the welfare of directors and management without necessarily considering the impact of the activities of that corporate entity beyond the immediate corporate structure, or devoting resources to satisfy other stakeholders in the chain. And that is why the topic or the theme of our discourse is ethical governance in the boardroom, implications for stakeholders, right? So the company is not necessarily set up or exists for the benefit of shareholders, directors, but then it extends to other stakeholders who are as important to the growth and sustainability of the corporate institution. Yes, so to build on a thriving or reputable business, it's necessary for companies to put in place corporate governance and accountability mechanism system for its board of directors, right? So we have the codes of corporate governance beyond even the shores of this country, and then specifically we have quite a lot of codes that apply to specific sectors of the economy, and also the code of corporate governance that apply to companies generally. But then the question is, how far does the corporate governance go in ensuring that companies are properly managed, right? So is the code of corporate governance or the codes of corporate governance that we have today, are they necessarily, a foolproof, right, to how companies should be run? Or we need to go beyond the letters of the codes to other, what I would say, things beyond what is written, subliminal, processes like ethics to determine how companies are properly run. But then before we go into the meat of the discussion, just to take us through basic definition of corporate governance. Now, the Calgary report defines it as the system by which companies are directed and controlled, right? But then beyond that is the definition further down the slide, which says the system of checks and balances, both internal and external to companies, which ensures that companies discharge their accountability to all their stakeholders. That is very important, not just the shareholders and directors, but to all their stakeholders, and act in a socially responsible way in all areas, right, of their business activity. So this is very, very important for us to bear in mind as we consider the topic that we need to go just beyond the codes to other activities or to other virtues that are necessary or needed to ensure the growth and sustainability of the economy, and of course, by extension, the companies to which they board and manage. Now, going further, let's now narrow down to ethics. What is ethics? And the concept of right or wrong. Unfortunately, there is no touchstone per se to determine what is necessarily ethical, but I think the concept of right and wrong is a universal concept that apply to wherever, whatever jurisdiction one comes from, or wherever, one's background or one's leaning, political or otherwise, right? So most corporate governance codes, of course, as we've tried to establish, seek to regulate the action of corporate entities by defining expected actions. However, despite the provision of corporate governance, we see that corporate failures continue to occur, right? And I think that touches on the fact that though we have the codes in written form, steps need to be taken to ensure that ethics is ingrained in the affairs of members of the board, right? Not just necessarily complying with the letters of written codes. So interest in ethical issues, corporate governance practices of modern corporations, I would say, particularly in relation to accountability, have invariably attracted a lot of public interest. And we see this following the high-profile collapse of several large corporations, which involved accounting fraud and unethical behaviors in management. And we see corporate scandals that have had an adverse impact on an organization's image. And therefore, in today's commercial landscape, the impact of corporate failings is far-reaching across industries and jurisdictions, right? And it's something that every stakeholder needs to pay particular attention to, right? Beyond just ensuring that the objectives of profitability of the company are met. Now, there was a global survey that was undertaken by KPMG recently in the heat of the pandemic in 2020. And this survey was conducted with by CEOs. KPMG conducted on behalf of CEOs. And it's interesting to see that a lot of CEOs are beginning to see the primary objective of the organization shift from purely profit to also consider their purpose in society. So while less than 23% saw the organization's overall objective within a narrow compass of managing shareholder value, right? We see 54% taking a broader purpose-driven approach focused on multiple stakeholders, right? And so whilst we see that the stakeholders, of course, primary stakeholders being the shareholders, the directors, and to an extent the employees, you have the external stakeholders that include, the customers, the suppliers, the contractors, then the host communities within which the companies operate, because they should also be very mindful of how their activities impact on the community in which they operate. And that, of course, will have a far-reaching impact to the extent on which you can get the cooperation of the host community in which you operate. So that is also very, very important to bear in mind. And so there is this gradual shift from just the grand purpose of making profit and ensuring that shareholders have their due return and the directors have whatever they need to carry out their activities, to other stakeholders that are equally important. And because if the customers are not well met in terms of the objective of ensuring that they are satisfied in the provision of services. If also there's loss of confidence, right, by consumers or clients, as the case may be, then that would have an adverse impact on the overall growth of the company. And as we've seen, corporate failures, insolvency, that are otherwise needless because those in charge of the affairs of the company have not taken particular, conscious effort in ensuring that ethics is what governs the activities of the company. Now, very key and very important is the parameters that have been set by the business ethics for, determining the existence of good corporate governance or ethical manifestation in board. And 4 of those, as you can see in the slides, board behaviors and board structures and processes, the purpose, strategy and vision for the business, values and standards, structures and procedures for oversight control. So in terms of the board behavior, the question is, how do the board members carry out their duties in a way that reflects ethical values such as integrity, respect, fairness, and honesty, right? And then the structure and processes in place to facilitate ethical behavior, avoid unethical ones, and ensure proper accountability, right? So appropriate board composition, committees, decision-making procedures, and all the like to ensure that there is the required checks and balances to check the activities or the actions of those who have been put in the helm of affairs of directing the strategic growth of the company. There is also the purpose, the strategy and vision for the business. What the board sees as its purpose for the business and what the business stands for. What are its strategic decisions and how do those decisions reflect in the business core values? Then of course, there's the values and standards. In other words, the board articulates and ensures the implementation of the standard of behavior it expects for business practices, the way business is done, and its role in society, including ethics, programs, and of course, very important, CSR initiatives, because that is the bit that impacts on the community. And you want as much as possible to have some calm and serenity in the community in which you operate, right, to be able to achieve your ultimate objective of profitability. And of course, structures and procedures for oversight control in the board delegation, right, to ensure that appropriate control and conducive to ethical business practices. So proceeding further to the next slides, ethical and corporate governance practices in Nigeria. Now, we've come quite a long way when it comes to corporate governance in the country, right? Our code is generally based on codes of other developed and established jurisdictions. But of course, before the general code today that applies across boards to companies, in the last 2 decades or so, regulators have also come to issue or put in place codes of corporate governance for the sector in which they have oversight of. So the Code of Corporate Governance for banks and other financial institutions was first issued in 2003 in response to the financial crisis of the 90s. Now, furthermore, we see the Code of Best Practices on Corporate Governance in Nigeria issued by the SEC, and then sector-focused codes such as the Code of Corporate Governance of Banks in Nigeria post the consolidation of 2006, and then the Code of Corporate Governance for Licensed Pension Operators of 2008 issued by the National Pension Commission, then the Code of Good Corporate Governance for the insurance industry in 2009, then we see the SEC reissued its SEC code in 2011, and also in 2014. And finally, we have the FRCN Code of Corporate Governance, which is meant to apply across board, even to private companies. Now, just to note, and I think where most of us here are aware of that, the code is not law in of itself, and so breach of the code in of itself would not necessarily, result, say, in prosecution or an action in court, right, for violation of its terms. So it's just meant to be a code of best practices that each company is required to comply with and adhere to, right? But that said, we've seen that a number of regulators have made the compliance with the provisions of the codes of corporate governance very, very critical and important. And so sometimes you can have sanctions from regulators. And of course, even third parties that intend to deal with the company are beginning to, hold compliance with the codes of corporate governance in very high esteem. And so, for instance, lending institutions like development financial institutions sometimes want to see to the extent to which companies and the board comply with the codes of corporate governance, right? So it's very key. And then going further, we'll see that the major bedrock or the foundation on which the codes, right, are set, try to put forward certain key elements. Number one, separating the roles of the CEO from those of the board chairman, and that is to ensure accountability and transparency, right? Prescription of non-executive and executive directors on the board, the executive directors to provide some level of checks on the executive directors who are those involved in the day-to-day management of the affairs of the company, improving the quality and performance of board members, introducing merits as criterion to hold top management position, very key, right? So some checks need to be conducted to ensure that that process is largely merit-driven and not because that in terms of a shareholders agreement, a shareholder has the slot, to appoint 1 or 2 persons to fill board position, right? That process in itself, it's not just enough for a nominating shareholder to put forward somebody. That person has to go through a thorough, rigorous check to ensure that there's not anything in that person's, affairs that will be untoward and then would not augur well for the advancement of the company, right? So that is very important. Of course, introduction of transparency, due process, and disclosure requirements. Transparency regarding financial and non-financial reporting. Protection of shareholder rights and privileges. Now, financial and non-financial reporting, interesting, the new law goes a step further to put very onerous responsibility and duties on the directors to hold them liable or responsible should it turn out that there are false or misstatements in the financial reporting of the company. And so situations like we see, in a number of cases where there's collusion between the board or management team with auditors, is something that the law has not taken very seriously. So even though I've mentioned that the codes in of themselves are not necessarily laws, and so you cannot on the back of it necessarily proceed against someone, we have these principles. Some of them have become entrenched in the laws, right, of our land, and the main law being the Companies and Allied Matters Act, breach of which could, entitle someone, to go after the hearing directors in court and make them accountable for their conduct or for their actions. And so you would say that the Companies and Allied Matters Act imposes, duties on directors, which are also hinged on ethical behaviors or ethical conduct. So for instance, under the law, there's a duty to disclose conflict of interest because it just doesn't make sense that they are, for instance, putting forward a contract and then you have an interest in that contract, perhaps you're a director or your spouse is a director or someone is a director in that company. Definitely there will be fairness in the procurement process of that contract. Duty not to misuse corporate information, right? And this has become very important, particularly where you see multiple directorship. You find people who are, in the board of multiple companies, and particularly where, for instance, one or two of those companies are competitors in a way. The law imposes a strict duty on such directors to ensure that there's no misuse of corporate information gained from one company and use it for the advantage or benefit of another company, right? Duty not to make secret profits, duty of care and skill. Care and skill is very important. So, of course, while the ethical foundation is very important and key, it just doesn't make sense for you to get people who do not have the necessary skill and competence to, direct the course of affairs of the company. It just simply means that with all the ethical considerations in place, that company do not have the strategic direction and course. And so the company definitely may not be going anywhere if those are the ends of affairs do not take properly reasoned judgment or decision-making process, right, in taking decisions on behalf of the company. And particularly, of course, I think the umbrella duty is the duty to act in the best interest of the company, right? And I say this very responsibly here, because when you talk of acting in the best interest of the company, it doesn't mean that you're acting in the best interest of the appointing shareholders, because as I mentioned before, where you have a number of shareholders, each shareholder so has to have some say and are given the right to appoint nominees to the board, right? And that being the case, even though the director acts, so to speak, on behalf of a shareholder in decision-making process, that decision is to be carried out for the benefit and the interest of the company, and such that where the interest of the company and that of the appointing shareholder are not aligned, then the interest of the company becomes paramount. And of course, where the interest of the company is better protected, it just has a ripple effect, right? It means that everyone benefits, right, including the shareholder, because that would mean ultimately, even though not necessarily in the near term, but in the longer term, it's it's better for the company in terms of profitability, which of course impacts the shareholders, and then every other stakeholder, including the customer, the client, and the communities in which the company operates. Okay. Moving on, please, if you can move on to the next slide. I think we can move on to the next slide as well. Okay, so implication for stakeholders. Stakeholder consideration is very key, and I think I've touched a bit on this, because you want a situation where there is confidence, right? Degree of confidence by members of the public, and of course, every other stakeholder that deals with that entity. Where there's suspicion that the affairs of the company are not properly run, there are shady deals, and you've been following the news media lately. There have been cases where very huge, companies with systemic importance, right, are seen not to be observing the strict code of corporate governance. And that, as it were, once it filters down, it can just have a run on such an institution, right? Because there's no longer public confidence. And so gone are the days where we think, it's just to, advance the cost of the company, make profit at all costs, because there are a lot more other stakeholders that are involved, such that those people may draw their support from such an institution, and which may have an adverse impact on the affairs of the company, right? And as you see on the highlighted or the bolded part of the slide, stakeholders and directors will profit from an ethically driven company, right? To the shareholders and directors, and then employees are more likely to show loyalty, and communities are likely to support the efforts of the company within their territory. So you see, it makes everyone happy. Everyone, is good. right, as against trying to satisfy the interest of just one segment of the stakeholders, right? And we see there are growing calls for companies to consider the environment and sustainability of the earth resource in their actions, and to a growing number of global firms such as BlackRock, KPMG, British Airways, Shell, Unilever, etc. are beginning to heed this call. So how does the activities of the company affect the environment? That is also a very key aspect today. And we see financing institutions begin to look at that, the equator principles. So these are things that that they are subliminal, they seem not to be very important on the face of it, but then they go a very long way in attracting the needed resources, right, to grow the company. Next slide, please. Okay, then further considering this topic, and I think we've touched on this, we corporate governance has been responsible for recent corporate failures in Nigeria and of course globally. And then questions of ethics or the right way of conducting business operations are implicit in every aspect of corporate governance and in every board decision and actions. Therefore, to stand the test of time, a commercial entity must have high and consistent standards of ethics, right? And then, yes, checks must be put in place. All board members must be called to account, right? And so we see the law putting in place processes for actions against directors or breach of their duties. And so, for instance, where a director has been unethically involved in making secret profit, there can be an action to recover secret profits. And of course, in terms of even the outside world, in terms of the external stakeholders, a winding up proceedings can also be made or put in place on just and equitable grounds to wind up the affairs of the company, where the affairs of the company has been seen to be a threat, right, to society. Restoration of the company's property, where any property of the company has been fraudulently diverted. And of course, an application can be made to the Corporate Affairs Commission for investigating any company's affairs. And actions in damages and compensation can lie against any defaulting member or director, as the case may be, right? So the law is replete with cases and examples where the directors remain accountable for any unethical conduct or or behavior, as the case may be. Next slide. We see, however, that there's some major obstacles, and people say the Nigerian factor. You institute matters in court, the actions stay forever in court. Lawyers, as they want to do at times, will bring unnecessary preliminary objections to seek to stall the process. And so that process is not necessarily as active as one would want it to be. And I think the recommendation, because we see the courts today becoming a bit more and more dynamic, setting up special courts for certain type of offenses. I would think the government may begin to look at cases of certain special courts to try breach of corporate governance or ethical principles which are ingrained in the law, right? So that all of this not get delayed in the whole mix of other court actions before the court. But beyond that is the important role sector regulators have to play, right, in ensuring the observance of corporate governance and ethical behaviors, within the boardroom. And so, for instance, we've seen the CBN that has been very active. We saw, at least the one I know I was very involved in 2010, 2011, sweeping reforms by the CBN, where we see boards, banks totally dissolved, right, because of the fact that, the banks, as it were, holds a very systemic place, right? in the society, and you can't afford, through the actions or inactions of a few, right, to allow depositors' funds to go down the drain, right? And so such decisions have to be taken to check the excesses of board members, right? So we say, of course, that, we say, and I think that there need to be some amendments to the laws as we have it today. So while CBN, of course, has that power to take such sweeping reforms by sacking boards and the like, some other laws don't necessarily have that. And one of such laws, for instance, is the power law, the Electric Power Sector Reform Act, right, which do not seem to have it in its main law. The regulator tried to introduce it via, or the regulator, NERC, tried to introduce those powers through a regulation and enforce it against an operator in the sector, but that operator went to court, and then the court said, no, if it's not in the main law, then you do not have the power of, the main law do not contemplate or give you the power to make such sweeping reforms via regulation, then you do not have the power to do that. So in other words, the legislature should be the one to make laws that give such sweeping reforms. But that said, in the absence of such laws which gives you powers, for instance, to sack or dissolve the board of a company, there are other steps or actions that we think that the sector regulators can put, some administrative sanctions, that they can put in place to check the excesses of board members. Yeah, so the rules, they are there, but sometimes people are more inclined, to the disobedience of those rules. And as you would see in the quote by Robert Sternberg, rules and regulations aren't the answer. There's always a loophole to be found. And the focus becomes navigating the system rather than doing what is right. We need leaders with strong moral compass, There's no science to this. It's not what you're taught in school. It's not what is written in the rule books or in the law, because man by nature would ordinarily want to deviate and do what is against, what is written in the moral codes. So we need leaders with strong moral compass, and that is the whole concept of ethical behavior or ethical conduct in the boardroom, and on which the principle of corporate governance rests on. Next slide, please. Yep. So I think more or less we've mentioned some of the things contained on this slide, right? So codes of ethics are typically required to outline acceptable behavior, right? Which is all good, provide a benchmark for self-evaluation, and further the achievement of high standards of practice, right? So as much as that exists, companies need to craft strong ethical values, which it will communicate to stakeholders and report on how it abides by and implement those values in its actions, right? So companies have to take this further step of putting in place codes of conduct, codes of ethical behavior, and communicating that to the wider public so that the wider public, the external stakeholders, know that these institutions hold ethical behavior and good corporate governance practice in high esteem. No company whatsoever can be too big, financially or otherwise, to fail. None. If the practice of good corporate governance is jettisoned, right? So effective corporate governance systems definitely, of course, will prevent abuse of power that stakeholders have bestowed upon directors and managers who represent their interests. Next slide. Okay, so recommendations. So what do we do to take this forward, or that we think the board should be aware of? Experienced professionals we think should be employed to design and oversee the values of companies, right? So each company has its unique characteristics or setup, and we see that some companies, definitely their actions would impact on the environment more than others, and so you need a carefully thought out process to engage the right kind of advisor to help craft the appropriate code, right, for that institution. Now, the process of board selection ought to be considered and carried out in line with the organization's need, with a diverse composition of directors, right? That is very important, of course, together with the fact that we just have to look at people with good or great ethical standards, in making board appointments. Chief executives and senior management desist from running corporate organizations like their personal businesses, and we've seen that happening in the banking sector, where chairmen or CEOs of banks just run the corporations like it's their personal business, and that is indeed very pathetic, knowing full well that you have depositors' funds at stake and other stakeholders, including the lenders. Directors and members of senior management should continually update their skills and capabilities in keeping with the demand of the boardroom. That is very, very key, as I mentioned before, because if you are not continually updated in terms of your skill set, your capacity, then there's just that likelihood that certain decisions will be taken that will be out of place and could bring down the entire corporate structure to its knees. It's very, very important. And that is why there's further a duty in the laws, Companies and Allied Matters Act, for directors to observe the duty of care and skill. And that is benchmarked, against what a director in similar position, right, would exemplify or would do, right? And so that's very important, to bear in mind. Next slide, please. Then, of course, the secretariat and company need to have a code of ethics, which should be reviewed and updated periodically. I've mentioned the fact that you need to have one, but then we need to have, through the help of the secretariat, to keep updating that code, the code of ethics. I'm not just on the code of corporate governance, which is a code as we have it today, but beyond that, we must have code of ethics that are unique to the particular organization. Company secretaries, competent one at that, should be employed to drive corporate governance because they are the custodians of the law. The company secretaries, then you need to have competent ones who are able to advise the board from time to time, advise the chairman of happenings and what needs to be done to really comply with the law, right? And of course, shareholders should be active at the AGMs and endeavor to check any excesses of board of directors. It's not just to come to board, to AGMs and vote and then take your dividend and you go, because if you do not check the excesses or the behaviors or conduct of those who you've put in charge of the day-to-day affairs of the company, then your investment as shareholders could possibly just go down. Now, we've seen this over and over again. For instance, for the sweeping reforms that were done to a number of the banks I mentioned in 2010, even recently, a few of those drastic actions were taken against one of the banks. The shareholders totally lost out because the view of the CBN at the time was, okay, at the least, we should be able to preserve depositors' funds, right? And also ensure that, workers are not laid off. So those are the primary concerns. And so in taking those actions, which has its support under the law, right, the shareholders lost everything, right, in those institutions. And so shareholders need to be very, very cognizant of this and ensure that they play the role of checking the conduct of the directors. Then, of course, in terms of the regulatory and governance, recommendation, there should be an annual corporate governance evaluation by an independent consultant, right? And we think that should be done. Sometimes we see regulators begin to do that a lot, where they engage external consultants to audit or evaluate the extent to which companies are complying with the codes of corporate governance. And there should be zero tolerance for corporate governance infractions. Right? So that is very, very important. I'm sorry. That's very important. Then adequate provision for whistleblowing should be entrenched in the organizational structure of companies, right? So that, staff, employees, other members of management are free to be able to report incidences of corporate governance infractions and then not being, no adverse actions taken against them. Now, of course, we think the role of the government is also very, very important. And as I've mentioned before, there may need to be some amendments to our laws, particularly laws that govern critical sectors of the economy, so that directors are more accountable for their conduct. As I said, the CBN Act, is very holistic in that regard. And the CBN, we've seen various regimes of, CBN governors not hesitating to wield the stick as the case may be. Our regulatory bodies need to improve on the oversight functions as stipulated in the relevant laws. Next, please. Yes, and so driving home now, the legal principle of separate legal personality of companies does not mean the total extrication of the importance of human behavior in the management of these entities. Yes, the company is a separate legal personality, separate from the shareholders, right, and from those who manage the affairs of the company, but then the law sees the directors, who are those involved in the day-to-day affairs of the company, as the alter ego of the company, right? The directing mind and will of the company, but the company is an artificial entity, cannot do anything of its own without the aid of, human agents, right? And so it becomes very critical that those persons who have the authority and the oversight over the affairs of the company, carry out their activities and functions with a high ethical standards, right? To ensure that the affairs of the companies are preserved. The Friedman position that corporations have the obligation to make a profit within the framework of the legal system, nothing more, and that the only duty of the business leaders is to make as much money as possible while conforming to the basic rules of the society is incompatible in the modern business landscape. There's therefore a need for greater ethical governance within the development of corporate governance. It is not enough for companies to comply with the different corporate governance codes, as we've mentioned in the course of this presentation. It is important that there's greater transparency on their ethical values to their stakeholders in order to drive earnings on the one hand, and then ensure long-term sustainability, which of course would benefit all stakeholders. And I think that's, in a nutshell, is the presentation. Thank you for your attention.
Thank you very much, Mr. Jonathan Aluju. Thank you for that insightful and deep and detailed presentation.